Blatstein, the physician founder, Physician Pre-Sentence Report Service. Today is June 3, and I'm going to go over today. This is mostly going to be directed at physicians, allied health professionals, even CEOs, COOs, anyone on the executive component or has anyone who tangentially interacts with the healthcare industry, be it a hospital, urgent care center, a hospital system. Allied professionals can be, anyone from nurses, physician assistants, dentists, any and all the professions, including physicians. And so I'm going to open this up, but we're going to be talking about the False Claims Act, which hopefully is not a new term for all of you, but let's go through that together because it could have critical impact on your freedom. My phone number is 240-888. I encourage you, if you feel that you're being, looked at or going to be indicted, whether civilly or criminally by the Department of Justice, Federal Bureau of Prisons, I'm more than willing to talk to you. Give me a call. The conversation's on me, no charge. White Collar Sentencing Mitigation Solutions is the company. Physician Pre-Sentence Report Service is what I do, but I'm going to pull down here to the article that I just did, and we're going to discuss it. And so it's going to discuss, and I'm going to talk about initially, it's going to be number one. The healthcare procurement fraud is the Department of Justice's one of their top priorities, as noted in their May 12th memorandum that they gave from the Department of Justice to Congress and to everyone else. And judges understand that no one wakes up one day and says no one's going to commit a crime. But that being stated, I came across an article from the American Medical Association, and I felt it very timely to review with you because it was pretty self-explanatory. And here we go. Fraud, they summarize, is going to be considered intentional. Abuse is going to be considered innocent. Everyone, whether you're, in the allied professions, medical, you've worked too hard to lose your life, your family, your license, or your freedom. And believe me, this is happening. It used to be that most of these crimes came under the criminal side of the law, which meant that you had to pay the funding back or pay the monies back in addition to going to prison. But subsequent to the election of Donald Trump, these criminal penalties have been turned into civil penalties, which means they just want to get paid. Now, I'm not a lawyer, and I'm sure there's more detail than that, but that is my initial non-attorney take. And so if you're a physician, as I said, allied health professional, or healthcare system CEO, you're going to be the number one target, and I'm going to show you why that is. They have you as the number one target. I'm going to open this up. This is going to be the memorandum that they went ahead and they released. And this is, we go to the top, it's May 12th, fairness, focus, efficacy, fight against white-collar crime. We can negotiate or discuss whether we believe, how much we agree with all of that. But here is where the rubber meets the road. Prioritization and associated policy changes. To combat these harms, the criminal division will prioritize and investigate and prosecute white-collar crimes. The first being waste, fraud, and abuse, healthcare fraud, federal programs, including procurement fraud. But I'm going to circle back again because we're going to be discussing healthcare fraud. There's other stuff here, but that is not going to be what I want to cover. It's purely on the healthcare fraud side. And so you could go look at this post article on my website, and that'll take you to that particular link. And as I said, one that was once considered criminal now can be considered, or rather is now considered civil. But you don't want to take any chances. If you feel that you're being watched, that someone has been asking questions, if you have someone who has come into your office or spoken to you, said that, that people have been asking questions about the practice, the business, take it seriously. You need legal representation, because what you do not want to do is turn what is a civil penalty into a criminal sentence, because going to prison is no fun. So here we have examples of criminal, which includes prison time. And this is where they still want their $6 million in this particular example. And we'll open it up here so you can see, and you'll be able to see the entire charge, if you will, the entire indictment. It's a medical business owner. Not only was he sentenced, but he has to pay over 6 million in restitution. But here is the change, and I'm going to go back, is that the reality is once someone comes out of prison, they're never going to, they can't pay that $6 million. They're just not going to have the ability to pay. Their career is toast, if you will, it's over. So next is where it's a civil penalty. And basically, no prison. All they want you to do is pay them. Now, again, there may be other collateral issues. It may be with the local medical board, it may be with OPM, it may be with insurance carriers. That I don't know. I'm not a lawyer. But here, the physician agrees to pay. So we'll click here. You can click here, go to the article again on my website. But the gentleman, the physician paid 3.5 million to resolve the claim. And so it makes sense that the feds were able to get, Department of Justice was able to get the resolution of the money in full. And in both these cases, and I'll repeat myself, legal representation is a must. If this turns into a criminal charge, then there are nuances in a criminal defense that go above and beyond what most lawyers delve into or include in your defense. In other words, there's kind of the lawyer legal component of your defense. And then once you hit a guilty or not guilty, if it's a not guilty, then everybody goes home happy. If there's a guilty, whether either you plead or by jury trial, then there is the non-legal components that interest the judge and that will follow you for the rest of your life in what's called a pre-sentence report. And so if you're unsure, ask me, but this is very important. If you want to give me a call, there's no charge, but this is probably the most critical point now before you get to what's called a pre-sentence interview. If it turns into a criminal charge. Here's the AMA's article on coding. And so I thought I actually created the link. I do have the link to it, but it's in the wrong spot. So while you can see it here, I'm going to open it up where it's bigger. And you can see it opening up over here. And we'll open that up a little more. And so and they cover some very important things. There are common mix-ups in coding, when unbundled codes, meaning that if there's a single code and you believe that you're entitled to break it up into individual codes, well, don't do it. You may get away with it once or twice, but if it becomes a habit, then they have great computers at the Department of Justice to figure this out. And then you may wind up being watched. Upcoding, these are on what's called evaluation and management codes. They're office visit codes. But when you go ahead and you increase their level of severity from, like a general type of interaction or office encounter visit to a very high encounter visit. And so if you consistently upcode, especially for their example here, if you consider yourself oncologist, where you think it's that you're entitled to that, yeah, it may not turn out in your best interest. They give an example of a psychiatrist was 500,000 and then permanently excluded from working with Medicare or Medicaid. And so, what he did, he said he billed for 30 to 60-minute face-to-face when he actually was only having 15 minutes. And so, it may appear to the physician as a minor detail, but if you get dinged with it, it's just not worth your license. It really isn't. You need to check constantly with the National Correct Coding Initiative edits and keep up to date to make sure that all your coding is accurate. These are automated prepayment edits that are reached by analyzing every pair of codes billed for the same patient on the same service date by the same provider to see if an edit exists. And so it's important. If there is an NCCI edit on one of the codes and one of the codes is denied, it may not be a great thing. For example, if you build for a skin lesion and a skin repair on a single service date, the CPT, which is the treatment code, may say that these are concluded together, except that if the repair was performed, let's say, on a different site from where the lesion was removed, then it's appropriate, but they have what's called modifiers, which most of the physicians understand. But failing to put that appropriate modifier can cause to give you a problem. For example, modifier 50, which is bilateral, to a procedure code means that it's done on both sides. of the body. And if you're using modifier 50 all the time, you're going to get flagged. Overusing modifier 22, increased procedural service, just make sure documentation is critical. If you excise a lesion and a crease on the neck of a very obese patient, this obesity may make the excision more difficult. Here, the modifier 22 with the report of the removal explaining the complexity of that procedure will provide you with that documentation to use that modifier code. Improper reporting. Here it's of infusion and hydration, but improper reporting, no matter what you do, should your records get audited, can turn out to be a problem. If you're using unlisted codes without documentation, if you wind up that you have to use this unlisted code to properly bill for your service, you just need to go ahead and properly document it and be as comprehensive as you can and explain why you're doing it that way. With a deeper dive, there was an article written by the Journal of the American in the Journal of the American Medical Association, and essentially what the author wrote was that what we're seeing is that major U.S. health companies have become involved in comprehensive big health platforms, where they're merging roles of insurers, providers, pharmacy, diagnostics, essentially all aspects of healthcare under one roof, and that can create a monopoly where it can adversely affect either a smaller health insurer type company coming into that market, or even the individual physician opening up a practice. There are definitely they are planning on using whistleblower programs to gather information. They've been doing this a lot in the general corporate world. Well, it's going to happen here too. The plan specifically targets healthcare, and the plan highlights fraud that endangers consumer health and safety. So this is going to be a big thing, but it focuses on violations of the Controlled Substances Act, Federal Food, Drug, and Cosmetic Act. It includes fentanyl-laced counterfeit pills, unlawful opioid distribution by medical professionals or companies. Here, they're lumping basically pill mill doctors or doctors that write for too many opioids in with the doctors, those that are manufacturing illegal counterfeit pills. And so, you're now being lumped into a larger group, which is not, it's going to make your life more miserable if in fact this has become part of your practice. Waste, fraud, and abuse public funds. These cases against Medicare, Medicaid, even COVID-19 relief programs, I have noticed, even as COVID-19 was 2019, 2020, 2021, we're now in 2025, and there are still cases of overuse of COVID-19 of the payroll PPP loans, of people thinking that they could get away with it, and all this stuff has a paper trail. And so, you just don't want to take a chance. Emphasis on self-reporting. Here, this is something you should take up with your attorneys. I don't know. I'm not here to tell you what to do. I did include the article here, and I'll open it up separately again so that you can see it. But voluntarily disclosing, is that they're going to go into delineation under this act, what applies, what doesn't apply, and near misses, and what happens if you have a warrant, if there's different things that warrant your resolution, it can be a problem. And then resolution in other cases, what works and what doesn't work. And so I'm putting all of this out there so that you understand that this essentially means that for whether doesn't matter if you're a small practice individual, or if you're a huge hospital system, or you're just a general hospital or urgent care center or a rural hospital, you need to have these policy and procedures in place as far as making sure that all of it that you comply with the requirements that have been put out by the Department of Justice, because it is you just don't want to have that surprise visit at your business, at your place of work, or at your home. Don't assume anything. Anticipate there's ongoing revisions that will be made by the Department of Justice on their own policies, because I'm watching it even up till today. And so to integrate your best practices into, you just want to keep your policies and procedures, best practices, whether it's informed by your own private counsel, by local or national associations, or even malpractice carriers. But you want to have guidance as you make sure that you have best practices within your particular business, hospital, or your own practice. Because should you get that unexpected visit, you'll feel much safer if you have everything already spelled out and you're doing everything above board. I appreciate you taking the time to listen in today, and I hope you have found this helpful, and have a safe day.